Okay, welcome back, honourable members. Just remind people we are now up to clause 25. The question is that clause 25 stand as printed. Those of the opinion say aye, to the contrary no. I think the ayes have it. The question is that clause 26 stand as printed. Aye. Those of that opinion say aye, to the contrary no. I think the ayes have it. People can wait for me to ask the question before they answer, that'd be great. Thank you. We're all keen. Yeah, I know, everyone's keen, including me. Okay, the question is that clause 27 stands printed. Leader of the opposition.
Thank you, Mr. Chair. Minister, what specific matters will you consider when assessing the financial and technical ability of proposed transferee, and which compliance history or past regulatory breaches will also be taken into account?
It would be the same as a fit and proper person test.
And on that, Minister, how will the government determine whether a transferee is a fit and proper person to hold a pipeline licence, and will that assessment extend to related entities, directors or parent companies that are also associated with the transferee?
No, I missed your question. You're saying how they relate it.
So when the government determines if a transferee is a fit and proper person to hold a pipeline licence, will the assessment also relate to some of the parent companies or the directors of that of the holder, the pipeline licence holder, essentially?
Yes, it will.
Okay. And will that be assessed by the department?
The department provide advice to me, and then I make the decision.
And that's under the discretionary powers through this clause? Yes? Did you say yes, or did...
Yeah, sorry.
Okay,
yeah. Sorry.
Thank you. So the next question with this clause, Mr. Chair, to the Minister. The clause requires a notation for a refusal of transfer of licence to be entered on the register. So, Minister, will the reasons for the refusal also be made publicly available to ensure transparency and accountability in any decision making related to the discretionary powers of the Minister in this clause?
No.
So nothing publicly available? No. Okay.
I think the Minister answered the question. Okay, the question is that clause 27 stand as printed. Those of that opinion say aye, to the contrary no. Aye. I think the ayes have it. The question is that clause 28 stand as printed. Those of that opinion say aye, to the contrary no. Aye. I think the ayes have it. The question is that clause 29 stand as printed. Those of that opinion say aye, to the contrary no. Aye. I think the ayes have it. The question is that clause 30 stand as printed. Member for Johnson.
Thank you. I do have some amendments to move to this clause, but I have some questions first. Thank you.
Yes.
Minister, proposed section 58V gives inspectors broad inspection and search powers. Do those powers, as currently drafted, extend to Aboriginal land?
Yes.
And do they extend to residential premises?
No.
So can the Minister confirm that an inspector could enter Aboriginal land without a permit and enter residential premises? Sorry, they don't extend. Yeah, sorry. Can the Minister confirm that Can the Minister confirm that an inspector could enter Aboriginal land without a permit?
Answer that question.
Yes. Can the Minister point to any specific safeguard in the bill as drafted that protects traditional owners from those powers being exercised inappropriately?
It's not relevant to the operation of the clause.
The clause is in relation to powers of entry onto Aboriginal land, so it's directly relevant.
I've answered the question.
Minister claims they've answered the question.
Minister, proposed section 58(7)(d) allows entry onto Aboriginal land without a permit where 7 days written notice has been given. Is that correct?
Yes.
And as noted.
Point of order, Mr Deputy Speaker. This is an
Member
important
Dale.
part of consideration in detail, and the Minister needs to stand and make it clear so it's caught on Hansard properly, otherwise there's a chance that it will be missed. So when he's answering those questions, he needs to stand and appropriately answer those questions.
Look, I'll take advice that yes, maybe stand, but he is giving very simple answers, yes and no.
It's to ensure that it's caught on Hansard,
Point of
so
order.
it's recorded. So when it is
Sorry, Leader of the Opposition, Leader of Government Business.
Deputy Speaker, you're in control here, not the member for Daly.
It's to ensure that when it's tested in court and they go back through...
Can you just step back? I'll just take some advice on the clerk as to what the protocol is. Okay, I take the member of Daly's point. It is better for Hansard if people do stand so they can turn on the mic. So I do ask people to stand in response.
Thank you.
Thank you. I'm just going to move, the amendment to 58V9. I was going to ask all my questions under this clause at once, but I won't do that because I know there's some other questions about the clauses. So, Mr. Chair,
so we're sticking to clause 30.
On clause 30, yeah.
That's all we're talking about, clause 30.
Yeah, we're talking about clause 30, but there's many sections.
Yeah, that's okay.
Yeah.
So, Mr. Chair, can I just confirm with yourself that I note the member for Johnson has got proposed clause amendments which she's going to put forward. Is the routine, should we ask the questions once the clause amendment has been proposed and after, or should we ask the questions before the amendment is proposed?
There's a couple of options. I think maybe ask all the questions you want and then move to the amendments if you wish. If that's okay. People agreeable on that one?
Okay, so I've got a series of questions across all of clause 30
and then we go
some
through the amendments.
specific
People happy with
amendments.
that?
Okay, thank you. Minister, as noted in submissions, if a notice period is possible, a permit application is also possible. Minister, can you explain why the government treats these as alternatives rather than things that should happen together?
Yeah, the licensees can enter if they get a direction from the department.
I'm sorry, Minister, can you repeat that? I didn't catch it.
Licensees can enter if they get a direction from the department.
Can the Minister explain, in submission said that there was an unacceptable risk of damage to sacred sites in the way this clause is written, and the department's response was that entering Aboriginal land to perform NT functions is not an offence. Can you explain how avoiding an offence addresses the concerns about actual physical damage to sacred sites?
That's not relevant to the clause.
Minister, the permit exemption in this bill under 58.7K2 applies not just to inspectors but to any person acting under a ministerial CEO compliance direction. Is that right?
Yes. Yes.
So a private contractor directed by the Minister to undertake works could enter Aboriginal land without a permit?
Not a private contractor, the licensee.
If a private contractor is so the Minister could not direct a private contractor under this clause?
We would direct the licensee.
Minister, sorry, that's on the next clause. Just bear with me for 1 minute, sorry. I'll pause for now, hand over and...
Leader of the Opposition.
Thank you, Chair. Minister, what would constitute reasonable steps and due diligence in the purpose of establishing a defence to non-compliance with a ministerial decision?
So non-compliance with the ministerial direction would be a defence. There's no defence to that.
Minister, what evidence will the licensee be expected to provide in order to successfully rely on the defence if they took reasonable steps and exercised due diligence to prevent the offence?
That would be a case-by-case scenario of what the situation was.
And that would be determined by the department or the minister?
If you're talking about an offence, that would be the court.
But who would refer it? It would be the department or the minister?
So the department would prosecute and it would become the prosecutor, and then they would have their right of reply in the court.
Thank you. Minister, can a licensee still rely on this defence when they're aware of a direction but failed to fully comply due to operational, financial or technical difficulties?
Well, that's a hypothetical question, and you outlined 3 different defences there, so it's pretty difficult to answer that question.
Minister, how will the government distinguish between genuine attempt to comply with the ministerial direction and a situation where the licensee has simply failed to prioritise their compliance?
It'd be a case-by-case.
Minister, does the existence of this defence risk creating uncertainty around enforcement, particularly when there may be disagreement about what constitutes as, quote, reasonable conduct in circumstances?
No.
Minister, will guidance be issued to industry to outline the government's expectations and through the department regarding compliance with ministerial directions and the operation of due diligence defence?
No.
Minister, why has the government chosen to retain this defence in circumstances where a ministerial direction may relate to serious safety, environmental integrity risks involving a pipeline?
It gives the some flexibility to the licensee if we prosecute them.
Okay. Member for Johnson, I'll just remind you, you've got 4 proposed amendments. If
Yes,
you do
thank
them,
you.
can you just step through them one at a time?
Yeah, I will. Thank you, Chair. Chair, I move Amendment 3 in Schedule number 057 IND to Clause 30. This amendment replaces proposed Section 58V9 with a provision that explicitly prevents inspectors from entering Aboriginal land without a permit under the Aboriginal Land Act. This reflects fundamental rights that apply across our legal system. The permit requirement under the Aboriginal Land Act exists so Traditional owners know who is coming onto their land and why. This needs to be explicit in the context of the Bill's broad inspection powers to ensure that that protection is guaranteed. So I move the amendment.
Are there any other speakers to the amendment? No? The question is that the amendment be agreed to. Those of that opinion say aye, to the contrary no. No. I think the noes have it. Member for Johnson.
Thank you, Chair. Chair, I move Amendment 4 in Schedule number 057 IND to Clause 30. This amendment omits proposed Section 58(7)D entirely. That section allows entry onto Aboriginal land without a permit where 7 days written notice had been given. As I talked about both in my speech earlier and earlier today, if there's time to give notice, there's time to apply for a permit. The department's response that performing functions under NT law is not a Commonwealth offence is a narrow legal point that misses what the permit system is for. the permit system, as I said earlier, is about traditional owners knowing who's coming onto their land and having the opportunity to respond. Removing this section means that a non-emergency entry must go through the permit process. Excuse me. Emergency provisions remain untouched, so I move the amendment.
Thank you, Member for Johnson. Are there any other speakers on the amendment? No. The question is that the amendment be agreed to. Those of that opinion say aye, the contrary no.
Aye.
Aye.
The noes have it.
Almost.
Got to get that right. Member Johnson.
Chair, I move amendment 6 in schedule number 057.
Amendment 5.
Amendment 5, sorry, in schedule 057 IND to clause 30. I think Minister, Chair, I've actually jumped ahead of myself, so that I just spoke to that clause previously. So I'll just move. Move that amendment.
Right.
So
Are there any other speakers to the amendment? No. The question is that the amendment be agreed to. Those that opinion say aye, the contrary no.
Aye.
I think the noes have it. Member Johnson.
Chair, I move amendment 6 in schedule number 057 IND to clause 30. This amendment replaces paragraph A and B of proposed section 58(7)(k)(2) to create a clear distinction between Aboriginal land and other land. For Aboriginal land, a permit under the Aboriginal Land Act is required. For other land, either consent or 7 days written notice is required. The permit exemption in this bill applies not just to inspectors but to any person acting under a ministerial or CEO compliance direction, including licensees, as the Minister advised a little bit earlier. As I've said, if a notice period is possible, a permit application is possible, and this amendment applies that principle consistently to everyone entering Aboriginal land under this bill. I move the amendment.
Are there any other speakers to the amendment? No. The question is that the amendment be agreed to.
No.
Those that opinion say aye, the contrary no.
Aye.
I think the noes have it. The question is that the clause stand as printed.
No.
Those that opinion say aye. Oh, sorry, no. Leader of the opposition.
Thank you. Thank you, Chair. Minister, on use subsection 58L, CEO directions. Minister, can you please clarify the distinction between a ministerial direction under section 58J and a compliance direction issued by the CEO under section 58L? And in what circumstances would each power be used?
Okay. The ministerial direction is a very broad direction, where the department one is not as broad, is narrow.
And just the last part of that question, Minister, was what circumstances each power would be used?
Again, that would be assessed on a case by case.
It's our favourite word, isn't it, this afternoon? Case by case. Minister, the CEO compliance directions intended to deal primarily with operational and technical compliance matters, while ministerial directions are reserved for broader policy, as you've said, but in regards to safety and public interest as well.
So what was the question?
Are the CEO compliance directions intended to deal primarily with operational, whereas the ministerial direction is predominantly around policy, particularly around safety and public interest?
The CEO direction is about compliance to the Act. Like I said, it's a bit of narrow, where the Minister is a lot broader.
Minister, what safeguards exist to ensure there are clear accountability and consistency between directions issued by the CEO of the department and also issued by the Minister responsible for the Act?
If I've got your question right, one direction comes from the department, one direction comes from the Minister.
Thank you, but are there, is there a process to make sure those directions don't conflict?
Yeah, the department provides advice, so that'll stop any conflict.
Thank you, but Minister, this particular section is about CEO direction. So is there a safety net between the CEO's discretion as the boss of the department and a minister's discretion with those sort of broader policy issues that you outlined versus the technical and operational that the CEO is responsible for?
Yes.
So what are the safeguards?
Like I said, the CEO makes directions about the compliance, and then the CEO gives advice to the minister. So any conflict would be dealt with within the department. If they think they can do it under their delegation, they would do it, and then the minister would get information to make a ministerial or a decision, and they would not conflict because they came from the same source.
Thank you, that's much clearer. Minister, the clause allows the CEO to direct a person to do something that would otherwise contravene the Act on the advice of the minister. Can you provide some examples of kinds of situation where the government anticipates this extraordinary power may be used and why it's been embedded in the new Act?
That would be a case by case.
But it obviously had to have been a warning that it may need to occur at some point, otherwise it wouldn't be put in. Okay. Minister, what criteria will you apply before advising the CEO and issue a direction that effectively authorises the conduct that would otherwise be unlawful under the Act without that discretion?
There would be discussions between the CEO and the Minister's Department about that first.
Thank you, Minister. Will any directions be issued by the CEO publicly? Will they be publicly disclosed, particularly when they involve environmental safety or operational risk affecting landholders or the community?
No.
Minister, how will affected landholders, traditional owners or nearby communities be informed where a compliance direction authorises conduct that would otherwise breach the Act? Bless you.
Again, that would be a case by case depending on who is affected.
Further questions?
What number are you? 50, 30.
No further questions.
Oh,
okay.
Oh,
Sorry, leader of the
I was just
opposition.
making sure the member for Johnson got an opportunity if she had any other questions for 30, because this is the bulk of my questioning. Thank you, Mr. Chair. Deputy Chief Minister, I'm now going to refer to 58M under clause 30. So that's the effective compliance direction on the need for further authorisation. Minister, can you please explain why the government considers it appropriate for a person to be exempt from obtaining separate statutory authorisations when acting under the compliance direction issued under the new subsection 58L?
So this section clarifies that if a person is not required to obtain separate statutory authorisation if they've been issued with a compliance direction. So if they've been issued a direction, that's the direction that they must follow.
So would there only be one compliance direction then?
Again, there would be a case by case, depending what the situation was.
Minister, what safeguards exist to ensure that bypassing separate authorisation processes does not undermine environmental, cultural heritage or safety protections that would otherwise apply?
Again, that would be a case by case scenario.
Minister, can you outline the types of statutory authorisations that may be displaced by this particular provision and whether this could include approvals ordinarily required under the environmental or land access legislation?
Again, it's hypothetical. It's a case by case. We'd assess it on each individual case.
Okay, so no, specifically it was around like the types of statutory authorisations. Are there anything that links specifically to this new clause and why the subsection's been inserted?
It's a case by case application, this clause.
Okay. Minister, if a person acting under compliance direction causes environmental harm or damage while relying on this exemption for this new subsection who ultimately bears responsibility, what are the avenues accountable that are available?
Again, that's going to be a case by case, depending what the requirement was, what the direction was, what the damage was, how severe the damage was, where the damage was taken. So again, what I'm trying to say, this is a case by case.
Thank you, Chair. Minister, I'm just going to look at 58N now, offence to contravene direction. Minister, can you please explain how a person can establish a defence to contravening a compliance direction if the direction itself was clear and legally binding?
So what's your question? How do you establish a defence?
Yeah, how does the person establish a defence if the compliance direction itself was clear and legally binding to contravening?
Okay, that would be a case by case because, again, depending what the action was. It's a hypothetical question. Depending what the defence was.
What was that? What the defence was?
Depending what the defence was, what the situation was.
Okay. Minister, what would constitute the reasonable steps and due diligence for the purposes of the defence under subsection 3, and what evidence would a defendant need to provide to successfully rely on that defence?
Again, it's a case by case scenario. You'd have to give you the full details of the case to be able to answer that question.
Minister, can a person rely on the defence where they partially complied with a compliance direction but were unable to fully comply due to operational, technical or financial constraints?
Again, that's a case by case, depending what the scenario was around that.
Minister, does the government consider there is a risk that the availability of this of this defence could weaken the enforceability of any CEO compliance directions, particularly when considering urgent safety or environmental situations that may arise?
No.
Minister, how will regulators distinguish between a genuine inability to comply with a direction and a deliberate decision not to comply?
Case by case scenario.
Minister, why has the government chosen to include both a high-level offence requiring intent or foreseeability and a separate regulatory offence, and in what circumstances would each of these offences be used?
Again, you need to give me some examples. This is a case by case, depending what the scenario was, what the damage was, what occurred. So it's a hypothetical question. But what I can say is these sections are there. You need to protect the environment and make sure that things go smoothly. And it's very difficult to answer any of your questions because this is a very technical piece of legislation, and we need to have case law and legislation and courts decide. So I'm happy for your line of question, but I'm just going to have to keep saying case by case because how do you defend someone who's speeding? There's 1,000 reasons you could be speeding. How could you defend someone who's had an assault? There could be lots of reasons. It could be self-defence. So without a case by case analysis of exactly what the scenario was leading up to using any of this legislation you're talking about, it's going to be very difficult for me or anyone to answer those questions other than say, I'm sorry, this is a case by case assessment.
Thanks, Minister. I do understand that, I'm thinking more of obviously the aftermath and how the actual clause will be put into practice. So that specific question was around obviously the clear decision by the government to include a high level offence inquiring intent. So obviously there's some type of anticipation, or maybe it is based on what's happened already in the Northern Territory. That's sort of what I was trying to understand. If there's a high level offence requiring intent versus what the separate regulatory offence could be. So that's sort of, anyway.
Again, to answer your question, we'd need details, but the answer I'm going to give you is a case by case.
Minister, given the significant penalties attached to these offences that are outlined in the proposed draft bill, will guidance be provided to industry outlining what is expected to satisfy the due diligence defence?
No.
Minister, does the burden rest on the defendant to prove that they exercise due diligence? And if so, why has the government chosen to reverse the evidentiary burden in this way?
The defendant always has the burden to prove that they can rely upon a defence.
Thank you, Chair. My next line of questioning, Minister, will be on 58P and 58Q, the stop work notices. Minister, what threshold must the CEO meet before issuing a stop work notice? What constitutes as reasonable grounds for believing circumstances exist and could justify cancellation or revocation of a permit, licence or a pipeline management plan?
Again, this would be a case-by-case scenario depending on the circumstances.
Is there any type of threshold criteria that the department's outlined already?
Again, this is a case-by-case, giving flexibility to the industry.
Yeah. Minister, can you provide examples of the kinds of situations where the government anticipates there could be a stop work notice? What would be issued to prevent or minimise harm to people, to workers, to property, to infrastructure or to the environment?
No.
Minister, how long can a stop work notice remain in effect?
Again, case by case, but the answer is a period determined by the situation, wherever that may be.
And Minister, is there an ability for a review or appeals rights available to a permit or licensee holder around the stop work notice?
Yes.
What safeguards exist to ensure stop work notices are used proportionately and not in circumstances where less restrictive compliance measures may be sufficient?
This is a discretion and it's a case-by-case scenario, and anyone can use this legislation, as in like the licensee, then it will be assessed on case-by-case by the CEO or by the Minister.
Minister, will affected landholders, traditional owners or nearby communities be notified when stop work notice is issued and in relation to activities occurring on or near land?
Again, case by case, depending on what scenario caused the issue of the stop work permit.
Minister, Section 58Q creates significant penalties for contravening the stop work notice. How can a defendant establish that they took reasonable steps and exercised due diligence to prevent the commission of the offence?
Again, that's really up to them to do that on a case-by-case scenario.
Minister, the next section of the clause is Division 4, Power of Inspectors. My question is...
Sorry, what? Oh, Division 4, yeah.
Yeah, of Clause 30. Minister, who can be appointed as an inspector under Section 58R, and does the person have to be an employee of the Northern Territory Government?
They have to be a government person.
Minister, can the CEO appoint external contractors, consultants or third-party specialists as inspectors under this Act? And if so, what safeguard exists to manage conflicts of interest to ensure that there is independence?
Yeah, if we don't have the expertise in-house, but they will be accompanied by a government inspector.
Thank you. And just the second half of that question was around managing conflicts of interest to ensure independence. Are there any safeguards for that?
Again, that will be a case-by-case scenario depending on what the potential conflict of interest is or could be.
Minister, is there anything preventing an employee, contractor or former employee of a pipeline licensee or related company from being appointed as an inspector under this framework?
Provided they're a government employee so the answer is no.
Okay. If a person connected to the industry can be appointed as an inspector, how will the government ensure that public confidence and integrity and impartiality of compliance investigations and enforcement activities?
It would be a case-by-case scenario depending on the person.
What qualifications, Minister, expertise or experience will be required before a person can be appointed as an inspector, particularly given the extensive entry, seizure and investigative powers that are provided under this division of the clause?
So they're engineers with at least 10 years in experience in the industry.
Thank you. Minister, will inspectors receive mandatory training in environmental protection, cultural heritage, Aboriginal land rights and procedural fairness before exercising their powers under this Act?
They get training certificate for in government investigations.
Minister, Section 58B gives inspectors broad powers to enter land, seizure items, compel...
58
58B?
E.
V.
B.
V for, I don't know what the...
Bravo.
No, V. V like for vacuum.
Victor.
I got Victor. There, I couldn't
V.
remember
Victor.
the...
Oh, okay, sorry.
Victor.
I thought you said B for bat.
Oh, I'm going to ask my question now that we know what the letter is. Sorry, Minister. Section 58B for Victor gives inspectors broad powers to enter land, seize items, compel answers and operate drones. So what oversight mechanisms exist to ensure that these powers are exercised proportionately and appropriately?
Again, the inspectors undergo training for a Cert 4 in government investigation.
And Minister, can an inspector compel a person to provide their passwords, access to digital systems, or under Section 58B, what safeguards exist to protect commercially sensitive or personal information?
Thank you. So the inspectors can use their powers if they're... I'm just trying to phrase it correctly. So the inspectors can use their power to do what they need to do if they're acting in accordance with the legislation. So they can't use it for anything else. They need to, it's very narrow what they can do. And provided they're acting within the course of their duty, there's a whole list of things that they can do.
So yeah, through that training, essentially they can compel somebody for those examples that were provided, but it would be under the frame of what is within their scope as their qualifications.
And again, it would be a case-by-case scenario of what they're investigating.
Thank you. Minister, Section 58ZC, Zulu Charlie, removes the privilege against self-incrimination. Why does the government consider it necessary to abrogate such a fundamental legal protection in this particular context?
58ZB.
Yes.
Yeah.
Interference with seized item.
ZC.
C.
Charlie.
Privilege against self-incrimination.
And what was the question again? Please?
Sorry, the second half was why is it considered necessary to abrogate this fundamental legal protection in this context? Removes the privilege against self-incrimination.
So if you read Section 2, if they give them the information, is not admissible in evidence against them.
Minister, while Section 58ZC provides direct use immunity, can information still be obtained from a compelled answer to still be used in the context of supporting an investigation or a prosecution against that person?
If you go to ZC, information is not admissible in evidence against a person in a civil or criminal proceedings, except if they falsify or they're not truthful in an answer.
Minister, 58ZD allows inspectors to enter Aboriginal land without a permit under the Aboriginal Land Rights Act of 1978. What consultation occurred with land councils and traditional owners before introducing this power?
That's not relevant to the clause.
Well, it's actually part of your Division 4. of clause 30. So I'm not sure where else I could ask it. If it's in clause 30, we're on clause 30. Power of inspectors, division 4.
I answered the question.
Well, no, you said it's not relevant. It is relevant. It's a whole new section, 58ZD. So, Minister, I'll ask again. This section, 58ZD, in Part 4 of Clause 30, your bill, allows inspectors to enter Aboriginal land without a permit under the Aboriginal Land Rights Act of 1978. What consultation occurred with land councils and traditional owners before introducing this power?
It's not relevant to the clause, but the land councils were briefed on this bill.
All right, briefed, not consulted. Thank you. What accountability mechanisms apply if an inspector exceeds their powers, if an inspector acts improperly, or causes damage while exercising powers that are covered under this Act?
If an inspector operates outside their powers, then they will be dealt with under the Public Service Employment Act.
Thank you. Minister, can a person challenge or seek review of a direction issued by an inspector under the Section 58ZG before penalties for non-compliance can begin to apply?
Yes, they can.
And Minister, what constitutes reasonable steps and due diligence for the purposes of the defence to offences under Section 58Z and 58ZH, and what evidence would a defendant need to rely on that defence?
Again, that would just be depending on the circumstances, a case-by-case assessment.
Minister, does the government anticipate inspectors exercising these powers independently, or will they always be covered under the PSEMA?
They'll always be covered, provided they're operating within their powers.
Thank you. And will there be specific practices that operate under the direction of the CEO or the Minister that could, I guess, be a risk to compliance matters, or will they always operate as that government employee?
They operate as a government employee.
Thank you. Next section of Clause 30 still, Mr Chair, being very patient. Part 5C, entry to land. Minister, can you explain how these entry provisions are intended to operate in practice on Aboriginal land, particularly where entry may occur without a permit under the Aboriginal Land Rights Act of 1978?
So under the direction or from the Minister or the CEO, they can enter land to comply with directions.
The directions of the Minister or the CEO, or both?
Both.
Okay. Minister, what consultation occurred with land councils and traditional owners before introducing the provisions that allow entry onto Aboriginal land without a permit?
Again, the land councils were consulted, and they also attended the scrutiny committee.
Minister, will land councils be informed if of a direction that's been issued that may result in entry onto Aboriginal land?
It depends on the circumstances. It will be a case-by-case.
So yes and no, essentially.
It depends on what the circumstances are.
Yes and no. Minister, while the clause requires notice to be given to the owner or the occupier of land, can you please clarify whether our land councils will also receive notice when entry relates to Aboriginal land held under the Aboriginal Land Rights Framework?
Yes.
Thank you, Minister. In circumstances where there may be uncertainty about who is the occupier of Aboriginal land is for the purpose of giving notice, how will the NT government ensure traditional owners and affected communities are properly informed?
Again, it'll be a case-by-case scenario depending on where it is, which community there's a whole range of factors that would be taken into account.
Minister, subsection 58ZK7 removes the requirement for an entry permit under the Aboriginal Land Rights Act of 1978. What safeguards will replace the scrutiny and oversight that would ordinarily occur through the regular permit process?
The directions will be issued provided those people are acting within their power to enter. So they're very limited. They can't just have a permit and go anytime they want. They need to go there under direction to complete the direction by the Minister or the CEO. So it's very narrow what they can go on there for.
And Minister, can employees or contractors of a licensee enter Aboriginal land under these provisions without any direct government officer being present or supervising their activity?
Yeah, so if the licensee is directed to do something like fix a leak or whatever it might be, and maybe they'll have their own welder, for example, or they'll engage a contractor to come and fix that. So the licensee is directed to do something, and then that licensee fixes whatever the issue may be. Again, very difficult to answer because it's case by case. Could be anything.
Minister, what mechanisms will exist for land councils or traditional owners to raise concerns or object if they believe entry powers are being misused or are going beyond what is reasonably necessary to comply with their direction?
They certainly can write to the Minister, they can write to the department. If the department gets notified, it'll come up the chain to sue. Again, it'll be case by case depending on what it is, but they will, and when they could be the Aboriginal land, could be anyone, could be private land, always got the ability to write to the department or write directly to the Minister or their local member, whoever that may be, that can come up through the chain as well. So there's certainly lots of avenues to be able to get any concerns they may have to the relevant person.
Thank you, Minister. And in emergency situations where prior notice may not be possible, how will land councils and traditional owners be informed about what's occurred on Aboriginal land and any remediation activity that may be required?
Again, like I said, word emergency, it'll be a case by case depending on what the emergency is.
Minister, does the government intend to develop protocols and agreements with land councils regarding communication, notification and conduct expectations when these powers are exercised on Aboriginal land?
No, but there will be some common courtesy. We know that a lot of the gas companies have got land use agreements. They've got TOs working for them, for example, I know about. So there'll be that communication. So the technical answer is no, but in reality, there will be lots of informal discussion, informal negotiations. In fact, you might find that the traditional owner or someone from the traditional owner's family will be on site because they're working there.
Thank you, and that is a good story, but of course that also would put that traditional owner in conflict of their employment as well as their, maybe their land and cultural obligations. So, a slight statement, if I would recommend communication, notification, MOU with the land councils. Minister, next question. Section 58ZN creates an offence for obstructing a person acting under these provisions. How will traditional owners be made aware of the legal consequences if they attempt to prevent access to their land?
Just like everyone, the rule of law applies to everyone. It's a matter for them, but again, there will be discussions. There will be a talk between the gas company or the mining company. So there's all that discussion happens behind the scenes. And if there's any queries, of course, and we know the land councils already know about this legislation. They put this submission in, so there's nothing to stop the land councils going out and contacting the people they represent to inform them as well.
And Minister, given this sensitive nature of cultural and sacred sites, what safeguards are there to ensure that emergency entry powers are not exercised in a way that could inadvertently damage culturally significant places?
Well, if we're talking about a pipeline, for example, there would already be a land use agreement. There will already be sacred site clearances. So, and they'll be in an easement where that pipe is. So all those sacred sites and culture would be either marked within that easement, and they would know, and there will just be discussion. So, and they'll go in there, and that's already done prior to the pipe being laid in the ground, for example.
Minister, if damage occurs on Aboriginal land as a result of activities undertaken under these powers, what practical avenues will traditional owners have to seek compensation or remediation?
That would be through the land use agreement.
And Minister, can decisions relating to entry on Aboriginal land under these provisions be reviewed by the tribunal? And if not, why has the government not provided specific review rights given the breadth of these powers?
So look, any landholder, anyone's always got judicial review available to them, but this is about trying to make sure if there's an urgent application to go and fix the problem so there's no more environmental damage, or fix whatever the issue is. Like again, it's a case-by-case scenario because we don't know what the emergency might be, but it's really about trying to get whatever the problem's fixed as soon as we can to stop any further damage to the environment.
Thank you, Minister. And just a snapshot of that answer, it could be reviewed by the tribunal, is that correct?
No.
Okay, you can't. All right, thank you. Minister, when in the Act, when the Minister or CEO exercises discretion under this Act, are they bound by AS 2885, which you spoke about before the lunch break, or can they depart from it if they consider it appropriate?
Look, yeah, like everyone, we've got to comply with Australian standards and international standards. But like anywhere in the world, if there's an emergency that comes up and is not dealt with under that Australian standard, it will be dealt with quickly and safely to prevent whatever situation is occurring. It's very difficult to answer your question because it could be one scenario, it could be a million scenarios, but it's...
Minister, in regards to AS 2885, it contains minimum standards only. Does the government expect operators to exceed those requirements where local environmental cultural risks justify it?
They're the standards that we expect them to comply with.
Thank you, Minister. And the standards have 7 parts, so is there any specific section that you're referring to out of the standards of the 7 parts?
It depends case by case what you're talking about.
So with AS 2885, can you clarify, are there specific parts to that series or are you relying on it in relation to this clause?
I'm just relying, that's an Australian standard that if you're working in that industry, that's a standard you must comply with.
Minister, I know we've been referring to it. Is there a specific provision requirement that you can point to that addresses some of those issues?
I don't know what issues you're talking about. It's really a case by case.
Around compliance.
That Australian standard has got compliance on all sorts of things. There's well integrity and in construction, so that's the Australian standard. Just like if you're an electrician, you would wire a house to Australian standard. The same as this. If you're using this industry, you'd be expected to use the Australian standard.
And Minister, is compliance with the Australian Standard 2885 mandatory under this Act itself, under regulations, or through the conditions imposed on a licensee or a pipeline management plan?
It's under the pipeline management.
Under the pipeline management plan, thank you. Minister, when it comes to the AS 2885 standard freely and publicly accessibly to landlords and community members, or does it require payment fee to access?
You can go into the department and you can view it for free during business hours.
Like a portal system? Or like a website?
I think there's like a website that you come into the office and you can have a look at it.
Thank you. Minister, when the Australian Standards 2885 is amended or updated, does that mean that the existing pipeline management plans are automatically reviewed in the Northern Territory, updated to reflect the new standard, or how does that process occur?
The pipeline management plans are reviewed every 5 years and any discretion changes will be made in that.
Thank you. And who determines whether a pipeline operator is actually complying with those Australian standards in practice? The regulator, an independent assessor, or the licensee holder themselves?
I'm just trying to line up, what clause are you asking under here? Because
Clause 30.
is there any particular part? Because it's not relevant to the clause.
Well, all of the new sections are relevant. It's all about compliance and making sure that people have processes, specifically when they're talking about mining management plans, when they're talking about land access, Aboriginal Land Rights Act. So I think when we're talking about whether the standard of any industry, not just necessarily the mining industry, but any industry, need to make sure that there's a process of review, referral, compliance. And if we're looking at the Australian standards, which you referred to predominantly before lunch, that would expect that would transfer across to the Northern Territory, and trying to understand what impact, for better or for worse, that would leave either landholders or the licensee holder themselves if there's extra compliance measures through this act, through the new act that you're proposing.
Is there any further questions?
Yes. What consultation occurred with landowners, traditional owners, environmental stakeholders, Minister, regarding the reliance of the Australian Standard 2885 as a regulatory benchmark?
You're referring to a national standard, and that's across Australia.
Minister, if a pipeline incident occurred despite the compliance with the Australian standards, does the NT government consider compliance with the standard to be complete defence, or would it be under regulatory action?
Not relevant to the clause.
Minister, if there is any regulated substances that comply under AS 2885, such as hydrogen and carbon dioxide transport, which part of the standard would apply for the Northern Territory?
It's not relevant to this clause.
Further questions? No further questions? The question is that clause 30 stands printed. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it.
36 is the next one for me, Mr. Chair.
Sorry?
36.
36, yeah. Is it the wish of the Assembly that clauses 31 to 35 be considered together? Aye. There's been no objection. It is so ordered. The question is that clauses 31 to 35 stand as printed. Those that opinion say aye, to the contrary no.
Aye.
I think the ayes have it. The question is that clause 36 stands printed. Leader of the Opposition.
Thank you, Chair. Minister, why has the government chosen a limitation period of only 3 years for commencing proceedings under the Act, particularly given that the environmental damage or pipeline integrity issues may not become apparent until many years after the relevant conduct may have occurred?
3 years is standard period for civil type cases.
Thank you. And was there a consideration given to a longer limitation period for serious offences involving environmental harm, safety breaches or contamination? And if so, why was that approach rejected?
No.
So not considered out of the 3 years? Okay. Minister, can you explain why proceedings are limited to those 3 years for the CEO first became aware of evidence an offence rather than from when the offence was reasonably discovered?
Saying that's a standard in the courts in relation to civil type matters.
Minister, is the government concerned that complex compliance investigations involving pipelines, environmental harm or technical failures may take considerable time to uncover and properly investigate? And if so, is this potentially limiting the ability to prosecute serious misconduct in the industry?
No.
And what would happen in the case that a limitation period expires and then it was discovered that there was serious misconduct?
Well, it talks about once it's commenced within 3 years, once it was alleged offence was committed or they knew about it, first came to attention of the CEO. So that's basically impossible to do what you're saying about, because it actually says in 1C to the knowledge. So knowledge came 4 years down the line and no one knew about it. And once it comes to light and once the CEO knows about it, then you've got 3 years. And that's the same in all civil type law matters.
Thank you for explaining that. Minister, does this limitation period create a risk that licensee could avoid prosecution where evidence of wrongdoing only emerges after that 3-year expiration period?
No,
So they could still be prosecuted?
that wasn't the question.
No, you answered no. So could, after that 3-year period expired, could there still be a prosecution?
Yes,
Okay, thank you.
that's a different question.
All right, I did a follow-up question for you. I'm keeping you on your toes. Come on.
Okay, just keep focus on the questions.
Thank you, Chair. Minister, are there any categories of offences under the Act that will exempt from the 3-year limitation period, particularly where there are allegations of significant environmental harm or deliberate concealment of the non-compliance?
That's not relevant to the clause.
Any further questions?
Yes, thank you. It is, because we're talking about the limitation period and when somebody becomes aware of the possible misconduct. Through the Chair, Minister, through the Chair, what was the policy rationale for moving from the existing 6-month limitation period under the Local Court Criminal Procedures Act to a 3-year period, and what consultation informed that decision?
Like I said, 3 years is the standard period under the Limitations Act for civil type matters.
Super. Minister, what are proceedings restricted to being commenced only by the CEO if a person authorised by the CEO, and does this prevent affected landholders or communities from initiating prosecutions where they believe that the regulator has failed to act in their best interest?
If a landowner thinks that there's been a fail to act by the government, well, they've got their own civil type matters they can deal with. But we're talking about against this Act, where the CEO or the government would be the prosecutor.
Thank you. And so, Minister, in that case, it would proceed as a criminal hearing.
Well, like again, it's a case by case, whether it's a criminal, whether it's a civil. If the landowner wants to bring an action in court, they can. They have to go away and get their legal advice and work out whether it's a civil, they need to work out, or it's a criminal, they need to work out what section, what act, and they'll need to be the applicant or the prosecutor in any trial if they think something's happened. Just like, you know, I could go and prosecute someone for assault if I really wanted to.
And then, thank you, Minister, and through the Chair, so then, Minister, any of the non-compliance that then is found through the CEO/the department, that would then be the prosecuting line would come from the department to the licensee holder, essentially, if there was non-compliance or someone had breached the Act.
We're just talking about proceedings, so that's not relevant to the clause. We're talking about 3 years.
Okay, no further questions. The question is that clause 36 stand as printed. Those that opinion say aye, to the contrary no.
Aye.
I think the ayes have it. The question is that clause 37 stand as printed. Those that no speak. Those that opinion say aye, to the contrary no.
Aye.
The ayes have it. The question is that clause 38 stand as printed. Member for Johnson, you have an amendment?
Thank you, Chair. Minister, the schedule of reviewable decisions in this bill limits the category of affected persons to applicants, permittees and licensees. Minister, can you confirm that Aboriginal landowners and native title holders whose land is directly affected by a pipeline licence decision are not currently included?
They're not.
So, Minister, if an Aboriginal landowner believes a pipeline licence decision over their country did not properly account for their interests, what is their avenue for challenge under this bill?
They could go to the department or they could start proceedings in the court themselves.
As judicial review, you mean, through the courts?
It's a matter for them.
Minister, can you tell the chamber what going through the court, what judicial review would cost on average for a matter of this complexity?
No.
Minister, the department said that third-party merit reviews would create uncertainty for industry. Minister, can you explain how the uncertainty of a merits review process is greater than the uncertainty of the judicial review process that you've just said now is the only alternative.
It's not relevant to the clause.
I'll move on. I'll move my amendment, Chair.
Amendment number 7.
So I move Amendment 7 in Schedule number 057 IND to Clause 38. This amendment replaces the proposed schedule of reviewable decisions with a new schedule that expands who can seek merits reviews for the most significant licensing decisions, so that the category of affected persons now also includes owners and occupiers of affected land and native title holders. The Minister wasn't able to answer how much judicial review costs, but it should be an option of last resort. It's extremely expensive, inaccessible to most people. This amendment creates an accessible pathway. It doesn't create uncertainty. It removes the far greater uncertainty of litigation by providing a clear, proportionate review mechanism. The amendment also adds review rights for compliance directions and stop work notices that there were some questions asked about just previously, which is basic procedural fairness for the people to whom these directions are issued. So I move the amendment.
Are there any other speakers on the amendment? The question is that the amendment be agreed to. Those of that opinion say aye, the contrary no.
Aye.
The noes have it. The question is that the clause 38 stand as printed. Those of that opinion say aye, the contrary no.
Aye.
The ayes have it. Is it the wish of the Assembly that clauses 39 to 45 be considered together? There being no objection, it is so ordered. The question is that clauses 39 to 45 stand as printed. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Question is that clause 46 stand as printed. Deputy Chief Minister.
Okay. I move that amendment number 1 of this Government Schedule 57, where we insert the word in section into underline 7.
Are there any other speakers? The question is that the amendment be agreed to. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Are there any other speakers? Question is that clause 46 stand as printed. Those that opinion say aye, the contrary no. That the clause stand as amended. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Let's take it easy here. Then we've got 50. So I'll just step through a couple of these quickly then. The question is that clause 47 stand as printed.
Aye.
Those of that opinion say aye, the contrary no. I think the ayes have it. The question is that clause 48 stands printed.
50 on the next one.
Yeah, I know up to 50. I'm just stepping through these quickly. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Question is that clause 49 stands printed. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Question is that clause 50 stands printed. Leader of the opposition.
Thank you, Mr. Chair. Minister, what does this clause allow? Why does this clause allow the renewal of a second or subsequent retention licence despite the non-compliance of the licensee? And what type of non-compliance does the government consider sufficiently minor to justify its renewal?
Again, that would be a case-by-case scenario.
Minister, under what circumstances would the Minister under the Act refuse a renewal application because of licensee's non-compliance, and are there categories of these breaches which would automatically disqualify a licensee from renewal?
Again, that would be a case-by-case assessment.
Thank you. Will the department provide categories to then ensure that there's compliance and therefore breaches?
Again, it would be a case-by-case.
Minister, how will the determination of whether circumstances exist to justify granting a new renewal despite the non-compliance, and will those reasons be publicly disclosed?
Two questions. So it's a case-by-case, and then the answer, no, they wouldn't be publicly disclosed.
Minister, how does the government accept that allowing renewals despite non-compliance could undermine public confidence in the enforcement of licence conditions and regulatory obligations that are set out in the Act.
See, the non-compliance could be paying your licence fee 1 day late, or it could be a complete collapse of a well. So it's really a case-by-case scenario.
So would that essentially be minor and major breaches?
Again, it would be a case-by-case.
Minister, will repeated environmental safety or reporting breaches by a licensee weigh against their renewal, or could a company still retain its licence provided that the Minister considers the circumstances to justify it under the Act?
Again, a case-by-case assessment of the application.
What safeguards, Minister, exist to ensure that the discretion to renew licences despite non-compliance is applied consistently and not arbitrarily?
Again, it's a case-by-case scenario.
Minister, when considering whether to grant a second or subsequent renewal for shorter term, what factors will the Minister take into account? What additional conditions might be imposed?
Again, case by case, it depends on so many circumstances. I'm not being difficult, I'm just saying it's a really assessment on each application as it comes in that it would need to be done individually.
And Minister, when we talk about the retention of licences, are they not simply a warehouse for an extended period without genuine progress towards commercial development, or are there mechanisms within the department to ensure that there is integrity in those licences?
They have work program commitments they must meet to get to the next level, and if they haven't met those work programs, that would be considered in any renewal application.
Thank you. And Minister, can affected landlords, traditional owners, members of the public make submissions regarding a licensee's compliance history before any renewal decision is made?
No.
And Minister, does the government intend to publish guidance criteria through the department outlining how compliance history will be assessed in renewal decisions to improve transparency and accountability for public confidence in the industry?
No.
Any other questions? Question is that clause 50 stand as printed. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Is it the wish of the Assembly that clauses 51 to 57 be considered together?
No.
No? Member Johnson, which clause?
52. Also, Chair, I'm just wondering whether we have quorum in the chamber.
I'll ask, check. Yes, we do. So, sorry, which clause was it?
Clause 52.
52. Okay, so let's go through. I'll go to 51 first. The question is that clause 51 stand as printed. Those of that opinion say aye, the contrary no. I think the ayes have it. The question is that clause 52 stand as printed. Member for Johnson.
Thank you, Chair. Minister, how will the amalgamation of retention licences interact with Commonwealth legislation such as the Native Title Act?
You would still need an agreement under the Native Title Act.
And Minister, does the amalgamation under this bill constitute a future act under the Native Title Act?
It's not relevant to the clause.
It's about whether an amalgamation of a retention licence constitutes a future act, which is what this clause is about.
I've answered the question.
You said it's not relevant. The question is, does an amalgamation of retention licences constitute a future act under the Native Title Act?
I've answered the question.
Minister, you've said that it's not relevant, but it clearly is relevant. The answer was that it's not relevant. Are you able to answer whether or not it constitutes a future act under the Native Title Act?
Look, I'll give the Minister one more chance, otherwise we'll move on. No? Okay, the Minister says it's not relevant, so it's not relevant. Next question. No? Okay. The question is that clause 52 stand as printed. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Is it the wish of the Assembly that clauses 53 to 57 Which one are to? Yeah, 53 to 57 be considered together. There being no objection, it is so ordered. The question is that clauses 53 to 57 stand as printed. Those of that opinion say aye, to the contrary no.
Aye.
I think the ayes have it. Let's get up here. Oh, yeah. Yeah, I think that's this one here. Yeah. Question is that clause 58 stands printed. Leader of the opposition.
Thank you, Chair. Minister, under what circumstances does the government anticipate fees or levies will be waived, suspended or reduced under this provision?
Can I just go back? Did you read 57? I thought we went to 56. Did we miss 57? My note saying that we went to 56 and then I thought we were going to be 57.
No, we went through to 57.
You voted aye for it.
We're on 58.
Okay, all right.
Clause 58. We've
You
agreed
only
everything
voted
up
for
to
it.
58.
58, okay.
Okay. I know we're all getting a little bit tired, and that's
I
okay.
just wanna
I'm not
make sure we
tired,
did
it's
this
my
one.
time to
No,
shine.
no,
I'm
no,
right.
no.
Afternoons when I
I'll
peak.
confirm with the clerk. We've covered them all off.
Perfect.
Okay, so back to the Leader of the Opposition.
Thank
Clause
you,
58.
Thank you, Mr. Chair. Clause 58 for the
Let's
Minister.
do this clause by clause. Almost case by case, but... Sorry, let's move on. Come on.
No. Thank you, Mr. Chair. Minister, my question is, under what circumstances does the government anticipate fees, levies would be waived if they're suspended or reduced under this provision?
So again, it's case by case, but for an example, if there was an application and the government misplaced it or made a mistake and there was a fee attached to it and there was more work to be done, there would be a case then to waiver or suspend or reduce some of that fee.
Thank you. So more so an error rather than a sort of discretionary, in-pocket, in-kind sort of scenario. Thank you. Minister, what criteria would the Minister apply when deciding whether to waive, suspend or reduce a fee, and will the criteria be made publicly available?
Again, that would be a case-by-case application.
With the case-by-case example, will there be criteria to provide a framework for decision-making?
No, because it's a case-by-case. You'd have to consider any evidence or any information that the applicant may want to put before me or the department, and it would be considered case-by-case.
But surely, Minister, you see the issue. If there's not a criteria in regards to making a decision, then how can the public have confidence that the decision is being free from any interference? That if it's just discretionary, which you're saying under the case by case, I understand, I accept that, but surely there has to be a criteria to then have a discretionary power about, yes, that fits the criteria, or that's close to the criteria, yes, I'll say yes to it regardless.
If you're questioning the integrity of the department and the people working there, that's a matter for you. But we're talking about the ability to waiver and suspend and reduce annual fees or levy. And what I'm saying is that will be a case by case. And I gave you the example. Again, I don't want to sit here and talk about every example. It will be assessed case by case. And I really value the work that the department do. And I think they do a good job.
Thank you. It's one of the very rare things that we agree on. They definitely do an excellent job. But the question was specifically, what criteria would the Minister apply? We went earlier on in all the clauses, as you know, there is a ministerial discretion clause, there is a CEO discretion clause. My question is not about the department or the CEO discretionary decision. My question is specifically about how a minister may apply their discretionary powers when it comes to applying the approval and making a decision to waiver, to suspend or to reduce a fee. Surely a minister would need to have a criteria. If that's provided by the department, that's great. That's what I want to hear. But at the moment, it seems like there is no criteria whatsoever for a minister to make decisions. So if you are then approached by a proponent that you know, could be your brother's company, and then a stranger, then you may provide your discretionary powers to approve the one of your families as opposed to the independent one that's come to you. I want to make sure that the public has confidence that any discretionary power applied by the Minister for approvals does have some type of criteria. If it is passed on by the department, great, that's what I want to hear. That's my question.
It's passed on by the department.
Thank you. And will that criteria, Minister, be publicly available?
It's a case-by-case assessment.
So case by case it would be publicly available, or just a flat out no?
Case-by-case, but
Minister, can you please explain in terms of waiving or reducing fees around initiatives without an application from the permit or licence holder, and if so, if that is a decision that can be approved, what safeguards exist to ensure transparency and consistency in those decisions?
it comes up from the department.
Thank you. On the criteria that's not publicly available. Minister, does the government intend this particular provision to be used to incentivise particular projects or industries, such as hydrogen or carbon capture developments?
It will be used on a case-by-case basis.
And Minister, under the Act, will the Minister consider a licensee's compliance history, environmental performance or engagement with landholders and traditional owners before granting any fee reduction waiver?
It'll be a case-by-case assessment.
And Minister, how will the public know when fees or levies have been waived, suspended or reduced for a particular project for a particular licensee holder?
They won't.
So that's good transparency. Minister, could this provision result in significant regulatory costs effectively being shifted from industry onto taxpayer dollars, territory taxpayer?
No.
And Minister, what types of fees associated with environmental plans or approvals under the Petroleum Environment Regulations of 2016 does the government anticipate may be waived or reduced?
That is not relevant because that's really a matter for the Environment Minister.
Okay. No further,
Can you ask him? He's just sitting behind you.
no further questions?
No, I've got lots more.
Okay.
Minister, thank you, Chair. Minister, is there any limit on the amount of duration of a fee waiver or suspension that could be granted under this section?
No.
And Minister, will decisions to waive, suspend or reduce fees be reviewable, or will reasons of those decisions be published at all?
So you've got two questions there, and the answer is no to both of them.
Okay, no further questions. The question is that clause 58 stand as printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Is it the wish of the Assembly that clauses 59 to 70 be considered together?
No.
Sorry. Oh, sorry.
Yeah, government's
we've-
got 67.
We've got one here too.
67.
67 amendment.
Yeah. So I'll just do it again. Yeah. Is it the wish of the Assembly that clauses 59 to 66 be considered together?
Aye.
There being no objection, it is so ordered. The question is that clauses 59 to 66 stand as printed. Those that opinion say aye, to the contrary no.
Aye.
I think the ayes have it. Question is that clause 67 stand as printed. Deputy Chief Minister.
Chairman, I move Amendment 2 under the Amendment Schedule 57 GOV to insert whether or not the regulated substance is mixed with any other substance after substance on line 5.
Are there any other speakers? The question is that the amendment be agreed to. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Any other speakers? The question is that the clause stand as amended. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Okay. Now we're going to go up to 70. Is it the wish of the Assembly that clauses 68 to 70 be considered together? There being no objection, it is so ordered. The question is that clauses 68 to 70 stand as printed. Those that opinion say aye, to the contrary no.
Aye.
I think the ayes have it. The question is that clause 71 standard printed. Leader of the opposition.
Thank you, Chair. Minister, while subsection 2 states the Minister is not required to conduct an investigation into whether a person is fit and proper, under what circumstances would the Minister nevertheless decide that further investigation may be necessary?
It'll be a case-by-case assessment.
Minister, if serious allegations or concerns are raised about an applicant's environmental, cultural heritage, or compliance history, what steps would the Minister, in this case under the Act, take to independently verify the information provided by the applicant?
I would ask the department to go back and investigate.
Thank you. Minister, does the government expect that a fit and proper person test to rely primarily on self-disclosure by applicants? And if so, what safeguards exist to ensure that relevant misconduct is not omitted or concealed?
So again, the department would go back and check and make sure, but to add to that, if someone does lie in an application, that's an offence, and then the prosecution, or the department may prosecute that. So that would make it very difficult if they move forward, if they've got, they've lied to the department and they've been committed and convicted of an offence for lying in any future application they may have. So there's a big stick, I suppose you could say, to make sure that they do the right thing. And then again, like I said, the department will be there to investigate and look at anything that they may, claims they may have in their application.
Okay. Thank you. Thank you through the Chair. Thank you. Minister, what weight will the Minister give to contraventions or compliance breaches that have occurred in other jurisdictions outside of the Northern Territory, particularly where those matters may not have yet resulted in any formal convictions?
Well, that would be a weighty matter to consider, but it would be a case by case.
And Minister, under the Act, can the Minister consider the conduct of related entities, parent companies, directors or major shareholders when determining whether an applicant is fit and proper person?
Yes.
And Minister, how will under the Act, the Minister assess these matters relating to sacred sites, cultural heritage or environmental harm when applying the fit and proper person test?
It would be a case-by-case assessment.
And Minister, are there any categories of conflict, Minister, are there any categories of conduct or offences that would automatically disqualify a person from being considered fit and proper in this provision?
Again, that would be a case-by-case assessment on the application.
And Minister, under the Act, if the Minister is not obliged to investigate, is there risk that the fit and proper person test could become largely administrative box-ticking exercise rather than generally interrogating the integrity of any assessment?
No.
Minister, will the government publish guidance on how the fit and proper person test will be applied, including types of evidence applicants will be expected to provide?
The application form will be published online.
And will there be a decision attached to any publication
The
that say
application,
there is a fit and proper person?
the application form will be published online, and they'll be able to use that, and then they'll be able to liaise with the department if they need any extra help or assistance.
And can anyone view that database?
It's published online, so yes.
Thank you. And Minister, can affected landholders, traditional owners or members of the public provide information to the Minister regarding an applicant's conduct or compliance history before a proper fit and person test and decision is made?
That could certainly be provided to the department, and then the department would put that up as part of the whole process.
Yep. Thank you. And Minister, has the government considered establishing a mandatory investigation threshold where there are credible allegations of fraud, dishonesty, environmental breaches or cultural heritage damaging that may involve an applicant?
No.
Minister, given the broad discretion involved in applying the fit and proper person test, what mechanisms exist to ensure decisions are transparent, consistent and accountable?
I would assess them on a case-by-case scenario.
And will there be a criteria that will come from the department?
Yep.
Thank you.
Okay, no further questions. The question is that clause 71 stand as printed? Those of the opinion say aye, the contrary no.
Aye.
I think the ayes have it. Is it the wish of the Assembly that clauses 72 to 82 be considered together? There being no objection, it is so ordered. Question is that clauses 72 to 82 stand as printed.
Aye.
Those of the opinion say aye, the contrary no.
Aye.
I think the ayes have it. Question is that clause 83 stand as printed.
Aye.
Leader of the opposition.
Thank you.
Flag.
Thank you, Mr. Chair. Minister, who can be appointed as an inspector under the section 137G, and does the person have to be an employee of the NT government?
The answer is yes, but I do qualify that by saying if we need outside expertise because it's a very specialised field, we'd go out there and get that if we needed.
Similar to like one of the early clause answers.
Yeah, like it's a bit of common sense. You know, we'll do as much as we can, but we know that this field is a very specialised field. And if there's something that's outside of our realm of remit, what we don't want to do is make a decision without the right evidence and without the right experts advising us. So we would make sure that we get the right people in to give us the right advice.
Thank you. What a great answer. If only we apply that to all your legislation in government. Minister, can the CEO appoint external contractors, consultants or industry specialists as inspectors, which you've already outlined can happen? But the second part of the question to that, which can be standalone now that you've already answered the first part, what safeguards, Minister, exist to manage conflicts of interest and ensure that there is independence?
It would be a case-by-case assessment.
And Minister, is there anything preventing, this is similar to previous clause question as well, is there anything preventing a current or former employee, contractor or advisor to a title holder from being appointed as an inspector under this framework?
No.
Thank you. And Minister, given inspectors are empowered to enter premises, seize property, compel answers and require access to computers and passwords, what qualifications or training or accreditation will be required before someone can be appointed as an inspector on this division?
The government level 4 investigation.
Thank you. And Minister, section 137L allows inspectors to authorise another person to assess them. I'll start that bit again. Minister, section 137L allows inspectors to authorise another person to assist them. Can you please clarify who those assisting persons may be, whether they are subject to the same integrity, confidentiality obligations as the inspectors themselves?
Again, that would be a case by case, and again, it relates to the nature of the expertise required to help the inspector do the inspector's job. And
Minister, so I can be so bold to just go beyond that answer that was provided, if it was an independent contractor based on the expertise that were needed from the department, would they be bound by confidentiality?
Yes.
Thank you. And Minister, section 137T removes the privilege against self-incrimination when inspectors exercise powers under this division. So Minister, why does the government consider it necessary to abrogate such fundamental legal protection for this division?
What P or T did you say?
T.
T for Thomas?
Yes.
Tango.
Tango.
Tango. Again, as I answered previously, this really allows someone to give information, but again, that information will not be admissible in a civil or criminal proceedings.
Thank you. Minister, while the clause provides direct use immunity, can information be obtained through compelled answers still being used that are indirectly to support investigations or prosecutions against the person who's been compelled to provide it?
No, that anyone would have to comply with subsection 1 and subsection 2.
Okay. Thank you. And through the Chair, Minister, how can a defendant establish that they took reasonable steps and exercised due diligence to comply with a requirement or directions issued by an inspector under subsection 137Q and 137X?
It would be a case-by-case assessment of the facts.
Hey Minister, what evidence would a defendant need to provide in order to successfully rely on the due diligence defence to the offences under this division?
Again, it would be a case-by-case, depends what evidence they want to put forward. It's a matter for them when you're in proceedings, what evidence you bring to the court, or so it's a matter for that person to be able to put that information up.
Thank you, Minister. In section 137W, allows inspectors to direct a title holder to take actions in accordance with what is generally accepted as a good and safe practice. Minister, can you please clarify how those standards will be defined and who determines what is generally accepted?
Again, that's a standard industry term, but the direction would have clear parameters of what needed to be done.
Thank you. And Minister, what oversight and accountability mechanisms exist if an inspector exceeds their powers, improperly seizes property or causes damage while exercising their powers under this division?
That would be a breach of the Public Service Act.
And Minister, can you explain any of the decisions or directions issued that that issued by inspectors under this division, if they can be reviewed by a tribunal, and if not, what other mechanisms has the government put in place to ensure that there is confidence in this process?
So the decision is not reviewable, but the person who's been issued the direction can come to the department and have that assessed through the department.
Okay, no further questions. The question is that clause 83 stand as printed. Those that have opinion say aye, to the contrary nay.
Aye.
The ayes have it. Is it the wish of the Assembly that clauses 84 to 89 be considered together? There being no objection, it is so ordered. The question is that clauses 84 to 89 stand as printed. Those that have opinion say aye, to the contrary no.
Aye.
The ayes have it. Is it the wish of the Assembly that the remainder of the bill be taken together? There being no objection, it is so ordered. The question is that the remainder of the bill stand as printed. Those of that opinion say aye, to the contrary no.
Aye.
I think the ayes have it. The question is that the bill be agreed to. Those of that opinion say aye, to the contrary no.
Aye.
I think the ayes have it.